A legal custom is a legal custom is the established pattern of behavior within a social situation that can be objectively confirmed in support of what has always been done and approved by law. A claim can be made. A customary law, also known as constitutionary or unofficial law, exists when the following conditions are met. A certain legal practice is followed. It is regarded as law by the relevant authors, that means opinion jurists. The majority of customary law deals with community standards that have been in place for a long time in a certain location. However, the phrase can also refer to areas of international law where particular criteria have been widely accepted as appropriate base of action. For example, anti-piracy or anti-slavery legislation, see post humanis generis. Customary laws will have supported court decision and the case law that has evolved through time to lend extra weight to their rule as law and to indicate the trajectory of evolution, if any, in the interpretation of such legislation by relevant courts in many, but not all circumstances. Objective. Objective. After studying this course, students should be able to debate and point out the relevance of customary law, distinct features of African customary law, legal pluralism, Nigeria, nature, definition, and sources as an indefinite repertoire of norms, law as necessary rule, govern codification, international law within contemporary law system, as well as the features, benefits, and the drawback of law. Distinct features of African customary law. The most significant distinction between African customary law and received law, which is whether common law or civil law, is that although received law is concerned with the individual, customary law is concerned with the communities cohesiveness and the familiar rights. International African societies, the individual citizen is essentially considered as a link in a community chain. Complete respect for social order and necessity of achieving collective peace are crucial values that must be maintained according to another source. Fremont 2009, 150 page. The community rather than the individual is primary concern of African customary law. Individual rights are subordinate to broader communal law, communal goals, and the golden thread that runs through the nominative framework of African customary law is a greater concern with fostering community consensus. Examining the dispute resolution process of indigenous African legal system is probably the best way to understand this communitarian approach, unlike modern legal system where litigants compete before a purportedly neutral adjudicator who decide the case. Who decide the case. In African customary law, dispute resolution is conciliatory and involves the entire community, not just the disputing parties. The goal of this strategy is to maintain social peace. First and foremost, adversaries are encouraged to come up with their own solutions with the help of the community, particularly the elders, who are a significant aspect of traditional African dispute resolution and are regarded as a source of wisdom, experience, and good judgment. Another distinct trait of African customary law is that it is unwritten in its purest form. African customary law is defined as unwritten African traditional law that consists of a diverse set of principles, practice, and rules. Previously said, the elders are the custodians of numerous customary law norms and regulations, which are passed down verbally. As a result, determining the specific nature of African customary law at any particular moment in history is difficult. While this may appear to be a recipe for anarchy when viewed in light of the Western understanding of law as primarily a written amalgamation of rules and regulations. It is precisely this aspect of customary law that gives its greatest strength, making it dynamic, adaptable, and capable of changing the face of changing realities without the lengthy, expensive, and sometimes politically charged process of changing official law, whether through precedent or enactment. While numerous African governments have sought to codify customary law, the end result typically bears with similarity to the customary law as it exists in codified, ossified from Beer versus Magistrate, Kayelisha 2017. This is a case. A noble component of apartheid South Africa was the process of capturing, regulating customary law. Of course, codification had a practical benefit. It made it easier to determine and prove customary law, making it easier to determine, to administer, making it easier to administer. South Africa was a notable component of apartheid South Africa was the process of capturing and regulating customary law. Of course, codifying had a practical benefit. It made it easier to determine and prove customary law, making it easier to administer. The Constitutional Court of South Africa, however, recognized the harm done to customary law through codification in landmark case of Beer versus Magistrate, 2005. Official customary law, as it appears in textbook and act, is often a poor depiction, if not a distortion, of actual customary law due to the dynamic nature of society. Through customary law will be one that understands and accepts the changes that occur on a regular basis. The bill court went on to say that a critical issue about customary law will therefore be the question of whether a particular rule is mythical stereotype, which has become ossified in official code, or whether it continues to enjoy social currency, echoing African customary law expert Tom Bennett's observation in 1997. Another distinguished element of African customary law is how it's implemented. Traditional leaders, known as chiefs, heads, and the headmen, administer the indigenous customary law, which is passed down through the generations. Traditional leaders in pre-colonial Africa were viewed as protectors of the people's custom, values, and goals, and rules over disputes and social institutions such as marriage, as previously mentioned. While traditional leaders continue to rule over customary law today, they are virtually always governed by statutes, and dispute over traditional leaders' legitimate function in a post-colonial modern African state is still ongoing. We shall be discussing legal pluralism of customary law. The option of law approach typical The option of law approach typify colonial legal pluralism. Either state or customary law applied to a specific situation, and if customary law was applicable, it was either group or group B's law. Scholars working with empirical conception of legal pluralism quickly realized that actors with access to multiply source of law construct relationship, resolve disputes, and form complex social institutions like family, property, and international trade in the patchwork of local and mercantile law, religious law, state law, and international law. As a result, in Minagan Tabua, property and inheritance tiers incorporate elements of Indonesian law, local adult law, and Islamic law. People in poor nations establish their own social security arrangements which incorporate parts of state law as well as customary and religious norms. And if they relocate to a Western country, their official social security arrangements are added to miss. The instance of legal pluralism in modern and Western settings cited in section history of the concept above is bit similar legal electricism. Nigeria. Customary norms, religious beliefs, and social practice that influence gender differentiated land rights. There are many customary laws as there are villages in the country. Under the customary law that governs most indigenous places, women are not entitled to land in their own rights in most groups. This Nigerian method, the country recognizes 3 types of marriage: customary, religious, and civil law wedding. The wife is frequently seen as man's property in customary law marriage. She is generally not expected to accept any sort of equality. She's not entitled to same benefits as married women under the Marriage Act. She's more likely to be disposed after her husband's death. This is not the case for a man who inherits his wife's full estate upon her death. Polygamous marriage are possible under customary and Islamic law. Because marriage is a union of 2 families, parties do not have equal rights in terms of marriage, dissolution, and property rights under customary law. Women rarely inherit in customary tenure. Instead, obtain usage rights through their husband. Unmarried women are sometimes given land by their family, which they keep once they marry. Despite this, women's tenure security is shaky, especially when a man has many spouse to whom he may assign different fields each cropping season. Women's desire to invest in crop improving technologies or plant tree crops is hampered by this uncertainty. Married women are treated with more respect due to their status and the protection of their husbands. Despite this, wives are submissive to their husband and in-laws under customary law. A divorce or separated woman is stigmatized in some communities across the country, regardless of the circumstances of the divorce or separation. This is more apparent in east part of Nigeria than other sections of the country. Separated or divorced women in the northern can marry after 3 months. That is for northern side in Nigeria. The other eastern side has been stated above. The Enugu state in Nigeria ethnic group follows a patriarchal residential structure as well as a patrilineal descent system. Without women, the genetic links are traced from dads to sons because she is anticipated to marry a husband in a different place someday. A woman cannot have land or wish to build a house and is viewed as belonging to a separate society only in name of her husband or male child may or women obtain land in her marital home. This type of land is referred to as okabi, and is granted to her for farming. The following practices are in use and are permitted by customary law: early marriage, female genital mutilation, also known as female circumcision, violation against women, in which men are permitted to beat and harm their wives if they believe they have done something wrong. Further, the seclusion of women from public observation through the use of high walls, curtains, and screens erected within the traditional authorities and customs. Land in customary region is governed by chiefs, clan heads, lineage heads, family heads, indigenous communities, and land-owning families acting through their agent. Customary land is kept in trust for future generations through them. And the economic climate, as well as commodification of land and individualization of titles. The function of such traditional authority figures in allocating and administering land has evolved since colonial times. These traditional players have evolved from being caretakers and trustees of communal land to playing a prominent role in urban land supply and influencing opinion lands to secure approval before any communal family land is transferred. Inheritance succession de facto practices. Paternal inheritance is practiced by almost all ethnic groupings, depending on society. Land may be distributed among a land's male heirs or passed down directly to the eldest son upon his death. If a man has more than one wife, his property is divided equally between them and passed down to their sons. Land is rarely passed down to women, and only when there are no male heirs. The only common mode of land acquisition among rural people is inheritance. According to a case conducted in Enugu State area of Nigeria, the most typical way for women household heirs to obtain property was through inheritance from their spouse. When there was no way, women's inheritance rights were determined by the sort of marriage that was contracted between spouses, whether it was customary or statutory before he died. Precious, come and plug this phone for me. Before he died, the deceased property was frequently distributed to his dependents in line with customary law that applied to him. These customs were often unfavorable to women. In customary law marriages, the wife is frequently treated as man's property, and she is rarely expected to accept any form of equality. She is more likely to be disposed after her husband's death. This is not the situation for a guy who inherits all of his wife's assets upon her death. Inheritance regulation in Islamic law provides some protection for women's inheritance rights. Widows in Sharia legal system are permitted a 4-month and 10-day in-house mandatory grieving period to decide whether they are pregnant for the deceased husband. If they are not pregnant, after that time period, they are free to remarry. Widows inherit their husband's property along with their children under Sharia law. Women, on the other hand, are only entitled to a minor percentage of inheritance. Discrepancies / gaps between statutory and customary law. Despite the fact that Women's Property Act of 1882 gives women married under statutory law the right to acquire, hold, and dispose of property, and the Matrimonial Causes Act provides that they have a share of family property in the event of a divorce on equality ground. Women are unable to enforce their property rights in a court of law due to a lack of knowledge, financial security, and fear of antagonizing their laws in areas of marriage, dissolution, inheritance, and property rights. Women married under customary law do not have equal rights. Women can possess land if they buy it, inherit it, or are given to it by their husband. However, when they divorce, they lose the right to cultivate it. Although there are formal laws prohibiting some discriminatory, customary, and religious practices, such as female genital mutilation or podam, enforcement is minimal in practice. Although women may inherit property from their deceased husband under statutory law, property is usually dispersed among the husband dependents. According to the customary law in effect at the time of his death, despite the fact that Section 21 of the Child Rights Act establishes 18 as the minimum age for marriage and betrothal, and prohibits the arbitrary setting of the age of marriage based on customary law and traditional traditions. Early marriage continues to be practiced. The lack of a set marriage age in Marriage Act and Matrimonial Causes Act aggravated the situation. In some cases, statutory law encourages discriminatory customary laws. For example, in the northern half of the country, Section 55, Section 1D of the Penal Code enables a man to beat his wife for the purpose of the correction. Furthermore, indecent assault on females is considered a lower violation, a misdemeanor under Section 353 and 360 of Criminal Code Act CCA of Southern Nigeria. But similarly, assault on males are felonies. Serious offense. Nature, definition, and sources. One of the most important issues in recognizing custom is identifying the best methodology for determining what acts and norms truly constitute customary law, because it is not immediately evident how classic Western jurisprudence can be reconciled with conceptual analysis of customary law in any practical way. Some scholars, such as Komarov and Simon Roberts, have defined customary law norms in their own terms. However, there is still considerable disagreement, as evidenced by John Hunt's assessment of Komarov and Roberts' theory, and the preference of H.L.A. Hart's contributions. Hunt claims that has the conceptions of law overcome the conceptual challenge that scholars have struggled with articulating how customary law principles may be identified, defined, and applied to social behavior and conflict resolution. As an indefinite reporter of norms, Rules and Processes, a notable book by Komarov and Robert, aim to detail the body of norms that make up Tuwaswa law in a less legalized or rule-oriented manner than Isaac Chaparras. They use the Casalis and the Elebaga concept to describe Mewa Li Melao Ya Seswama, with Melao being regulation pronounced by a chief and Megwa being norms that become customary law through traditional use. They did remark, however, that the Swana rarely attempt to categorize the broad number of existing rules which they adopt the or differentiated nature of the normative repertoire. Furthermore, they observe the coexistence of blatantly contradictory norms that may span conflicts, either as a result of condition in a given scenario or because of their intrinsically incompatible substances. That means if it's not compatible, it is incompatible with the law. It will be null and void. This lack of rules classification and failure eliminate internal consistency between potential conflicting norms gives for a great deal of flexibility in dispute resolution. It is also seen as strategic resources for disputants who want to improve their chances of winning a case. The latter contradiction, particularly inconsistency of non-content, are usually resolved by elevating one of the norms tacitly for the literary to the symbolic, as they now theoretically exist in different domains of reality. This allows for accommodation of both. This is very contextual, demonstrating that standards cannot be understood in isolation and that they are subject to negotiation. Although there are a few non-negotiable rules, the great majority are seen and given substantive in context, which is considered vital to Swana culture. Komorov and Robert explain how the outcome of specific cases might modify the normative repertoire, because the normative repertoire is always in the process of construction and modification. The modification are justified on the basis that are simple acknowledge the factor transformation observations. Furthermore, the legitimacy of a chief decision is directly proportional to this legitimate. In development of legislative pronouncement as opposed to decision made in dispute resolution, the chief first discussion the proposed norm with his councillors, the councillors of headmen, and finally, public assembly debates the proposed legislation, which they may approve or reject. A chief can proclaim the law even if the public assembly rejects it, but this is uncommon, and if the chief proclaims the law against the public assembly's will, the law becomes mellow, but it is unlikely to be carried out because the effectiveness is dependent on the chief's legitimacy and the norms consistency with the people's practice and the changes in social relation and way. Comras and Roberts coined the term paradigm of argument to describe a disputant's linguistic and conceptual frame for constructing a coherent picture of relevant event and action in terms of one or more implicit or explicit normative reference. The complainant, who always speaks first, so provide a paradigm that the defendant can either accept and thus argue with or reject, and thus introduce his or her own paradigm in their explanation. Usually the facts are not contested here. If the defendant wishes to shift the paradigm, they will refer to the norms as such, even though norms are rarely explicitly mentioned in Swana dispute resolution, because the audience is likely to be familiar with them, and once paradigm is established solely by the way one presents one's case and construe the facts. After the normative basis conveyed by the parties or one of them, and thus not refer to norms using explicit language, but instead isolate a factual problem in disagreement and then make a judgment on it without explicitly referring to any norms or impose a new or different paradigm on the parties. Law as necessary rule govern. Komarov and Robert flexibility thesis of a repartition of standard from which litigants and adjudicators choose while discussing solution between them is unconvincing to Horn. As a result, he is preoccupied with disproving what he refers to as their rule skepticism. He points out that while the term custom often refers to convergent behavior, not all customs are legally binding. As a result of hard study, Horn distinguishes between social rules which have both internal and exterior elements and habits which solely have external features. Internal aspects are adherent, introspective attitude toward particular behavior that are thought to be mandatory according to a common standard. External features are manifested in predictable, observable behavior, but this is not required. As a result, according to Hart, social rules amounted to legalized custom. There are three further distinctions between habit and enforceable social standard, according to Hart. First, there is social rule that society disapproves of the variable from the norm and strive to avoid such deviation by criticizing such behavior. Second, when this criticism is viewed as a socially acceptable cause for continuing to practice the habit, it is encouraged. Finally, when members of a group act in a certain manner, not just one of the habits, or because everyone else is doing it, but because it is viewed as common norm that should be followed, at least by some of the members. On the other hand, recognizes how difficult it is for an outsider to understand the dimension of these criteria, which are dependent on internal points of view. International law. Customary law is a term used in international law to describe the law of nation or the legal standard that have arisen over time as a result of customary exchange between governments, whether based on diplomacy or aggression. Essentially, legal duties are thought to exist between states to handle their affairs in accordance with previous established practices. Within contemporary legal system, within civil law jurisdiction, customary law is a recognized source of law that may be subordinate to both statutes and regulations. When it comes to custom as a source of law in the civil law tradition, John Henry Merriman observed that while it receives a lot of attention in academic works, its value is slight and declining. On the other hand, legal pluralism refers to the existence of one or more varieties of customary law alongside official law in many nations around the world. See also list of national legal system. Long usage must be established in English common law. Long usage must be established in English common law. It is general premise of property law that if something has been done without protest for a long time, whether it is utilized a right of way or occupying land to which one does not have title, the law will eventually recognize the fact and grant the person doing it legal right to continue. In case this is referred to as customary right, something that has been done from the down of time with regard to a specific location may gain the legal status of a custom, which is type of local law. The legal requirements for determining what constitutes a custom are precisely in recent years. The most common claim has been customary right to anchor a vessel. Bait must have been used continuously for the same purpose by those who use it for 12 years or 20 years in case of royal territories and from the ancient time as defined by statutory case law. To give two examples, mooring practices that may have been established for 200 years by indigenous coastal fishing fleets on the past are simply inherited by the fact that today's recreational boat owners are coming. It is not the case, then it is far away. A group of birds houseboats that have been in the use of 25 years with a mix of owned and rented houseboats can clearly continue to be used by households whose owners live in the same town. Both the purpose of birds and the group of people who have benefited from customs need to be clear and consistent. Customary Aboriginal law has a constitutional base in Canada, and as a result, it is gaining traction. Customary law still exists and has a significant influence in Scandinavian countries. In certain developing nations, customary law is utilized in conjunction with common or civil law according to those Donovan and Getachew Asefa. Despite the introduction of civil law-based legal codes in 1950s, Ethiopia has more than 60 systems of customary law in place, some of them operating fairly independently of the former state's legal system. They give two explanations of the relative autonomy of this customary law system. On the Ethiopian government lacks the resources to enforce its legal system throughout the country. And two, the Ethiopian government has made a commitment to preserve this customary law system within its borders. President Askar Akef of Kyrgyzstan issued a proclamation in 1995 to revive local elders' Aksukwa courts. Property, tort, and family law would all fall within the jurisdiction of court. Article 92 of the Kyrgyz Constitution eventually contained the Asigwa Court as of 2006. Kyrgyzstan had roughly 1,000 Asigwa courts, including one in Bishkek, the capital. The recondo of his skills, national identity, according to Akef, is linked to the growth of this court. He linked the court to the country's nomadic origins in 2005 speech, extolling how the court showed Kyrgyz's ability to self-governance. Other Central Asian countries have a Asigwa court with varied levels of legal formalities. In the Horn of Africa, the Somali people follow a system of customary law known as Zia. It is still widely practiced throughout Somalia, including among Somali communities in Ogaden. The surge in economic activities since the fall of the provision of security in life, liberty, and property in wide parts of Somalia. In his extensive research of Zia, the law of Somalis, a stable foundation for economic development in Horn of Africa, Josh Attorney Michael Van Noten draws on his experience as a local expert in 2005. Mary Indian Okay, many Indian customs are recognized by legislation. The Hindu Act, for example, recognizes Hindu marriages rights. In Indonesia, the customary numerous indigenous ethnic groups, customary adat rules are recognized, and customary dispute settlement is recognized in Papua, Aceh, Gayo, Alas, Batak, Minangkabau, South Sumatra, the Malay region, Bangka, and Belitung. Even Kalimantan, Minasa, Gorontalo, Toraja, South Sulawesi, Tunet, the Moluccas, Papua, Timor, Bali, Lombok, Central and East Java, Sunda, and the Javanese monarchies, including the Yogyakarta Sultanate. In conclusion, for a long time, customary law was thought to be a relic of the past that would eventually go away. But it has shown to far more robust than anticipated. It is always evolving in relation to and in response to other normative regimes. It is always evolving in relation to and in response to other normative regimes, the most important of which are stated legal system and religious law, but increasing in response to international law, self-regulation, and other forms of regulations not emerging from the state or state-like organization are also new tweaks on the branch of customary law, which gives the notion of significantly large reach than the previous had. In this course, we've successfully discussed and learned about the customary law, distinct features of African customary law, legal pluralism, Nigerian method, nature, definition, and sources as an indefinite repertoire of norms, law as necessary rule govern, codification, international law within contemporary legal system, and among others. With this, I'm done with the lecture. Please, if there's any question. I'm done with the lecture.
Yes, I don't think there's any question. But if there's any, they'll leave it under the comment section and we'll get back to you. Thank you so much. Hello?